Hello, everyone. This is Steve, the Mad Lawyer, and today's episode explains common law rights versus the rights you obtain when you register your copyrights. And hopefully at the end of today's episode, you'll understand why it is really the best practice to register your copyrights rather than rely on common law rights. So first of all, as explained in a previous episode, common law rights are limited to unpublished works, and it's limited primarily to California. Some other states on a state-by-state basis may give you some rights to works that you create that you do not publish, California being the most notable, but the vast majority of states do not have any rights at all that will protect you if you do not register your copyright under the Copyright Act. So what rights do you really get if you go to the process and go through the expense of registering your copyrights? Well, first of all, you have a public record that you own the right. So if somebody wants to claim that he or she was the author of the work that you created, your astrophotography image or your YouTube channel, this is a public record that you can rely upon to demonstrate that you, in fact, are the owner. There's also a presumption of ownership. So if you hold the copyright registration to your image or your YouTube video, the law presumes not only do you have a public record of ownership, the law presumes you are the owner. And that's a very important step because you, as the copyright owner, have the burden of proof to demonstrate you own it. The next important factor is under the Copyright Act, you have the ability to enforce copyrights by filing an actual lawsuit for copyright infringement in federal district court, rather than in state court, which you might do in California under the common law rights. And this is where you really get teeth, is you have the eligibility for statutory damages, which I'll define in just a few moments. You have the ability to collect or get reimbursement for your attorney's fees that you had to outlay to file that lawsuit. And you get the costs of suit. So let's talk about this further in just a moment. But one of the other final things that you get is you get the protection against the importation of infringing works. So if somebody were to try to import, let's say, printed out images of your photographs, you could actually get the United States Customs and Border Patrol to actually stop importation of those products at the border. So they couldn't actually come in to the United States. Now let's talk about statutory damages, because this is where it really makes a difference. If there's no evidence of willful infringement, statutory damages are no less than $750 and no more than $30,000. So let's say somebody imports or brings to their webpage T-shirts that have images of your astrophotography or pictures of your nature photography, or some other image that you own the rights to. And let's say they make T-shirts out of it and try to sell those T-shirts. You can get damages of up to $30,000 without even having to prove any kind of willfulness. Now, if you can establish willful infringement, then you are entitled to get no more than $150,000. The question ultimately becomes, what is evidence of willfulness? Evidence of willfulness might include things such as if you've got the circle C and your name and when you published the work, that helps you prove that the public should have been on notice that you owned it. Or you can prove willfulness through some other way. For example, if you can track that they downloaded your image from your web page, and there is tracking software that can do that, that they downloaded it on a certain day, you can demonstrate through that kind of evidence that what they did was intentional, that they knew what they were doing and they did it anyway. That is the kind of evidence that will get you a willful infringement, which enhances your damages above the $30,000 ceiling up to $150,000. And let's remember that you also get reimbursement for your attorney's fees and court costs in bringing that action. Now, in future episodes, I'm going to talk to you about how you go about registering your copyright. And in fact, I might do actually a live episode where I show you step by step how to register your copyright online at the Copyright Office. And I've got a series of other videos I'm going to make consistent with this. I'm also going to cover topics in the future, such as how sometimes your copyright can also be considered your trademark, and you get additional protection for trademark law. That's even far more than what you can get under copyright. So that's what I have for today. I hope that if you like what I've got to say and you like the content, you'll throw me a like. You might consider subscribing to my YouTube channel, and we'll see you during the next episode. Thank you for watching.